Good morning, Judge. Court is now in session calling the matter of John Wilford versus Rachel Wilford.
For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. The court is in receipt of a proposed consent judgment divorce. It appears we have both parties present. Sir, you are John, is it pronounced Wilford?
Wilford.
Wilford, okay, and also Rachel Wilford is also present. Good morning, both of you.
Good
Can
morning.
you both please raise your right hand to be sworn? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
I do.
Thank you. We'll start with you, Mr. Wilford, since you're the plaintiff. Can you please state for the record your name and current mailing address?
My name is John
This
Wilford.
judgment has an address of Lambertville.
Correct. When we filed, we were still living together, but I have since moved out.
Yeah, when you signed the judgment, you didn't change the address, so you want that, is that correct?
Yes, Your
Okay,
Honor.
I'm sorry. You caught me off guard. Can you repeat the address again?
70.
Thank you.
Thank you.
Mr. Wilford, is it true that you filed a complaint for divorce with this court on about March 5, 2024?
Yes.
Is it further true that on the date you filed that complaint, you had to reside in the County of Monroe for at least 10 days and state of Michigan at least 6 months?
Yeah.
Is it further true that you married Rachel Brighton on October 22nd, 2022, and you recently separated?
Yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed?
Yes.
Is there any chance of reconciliation?
I don't think so, Your Honor.
Were there any children born or adopted during your marriage who are still minors?
No, sir.
And you signed your name to this proposed judgment proving the terms and conditions contained therein, is that correct?
Yes, sir.
All right, thank you. Ms. Rachel, can you please state your name and mailing address for the court?
It's Rachel Wilford.
Ms. Wilford, did you hear the testimony of your husband, John, this morning?
Yes.
Was his testimony true and accurate to the best of your knowledge?
Yes.
Are you currently pregnant?
No.
Did you also sign your name to this proposed judgment proving the terms and conditions contained therein?
Yes.
I'm going to walk through the terms of judgment with you. You both agreed it's relatively short-term marriage. You've agreed that spousal support is not awarded. You've already divided your personal property, so each will keep the personal property currently in your respective possession, free of any claim on the part of the other. There are no joint debts, so each will pay any debts in their own names. Each will keep their own automobiles, but any debt they're on, there's no real estate to be divided. And each party is awarded their own retirement benefits, whether it's a 401k or IRA or pension. Finally, Rachel is requesting restoration of her former name of Brighton. That's essentially it. When you get a copy of the judgment, Mrs. Wilford, you want to take a copy of the judgment to the Secretary of State and Social Security to facilitate that legal change of your last name, okay?
Okay, thank you.
All right, do either of you have any questions for the court?
No.
Well, the court appreciates your cooperation in filling out the judgment and returning it to the court in time for this pretrial conference so we can move things along without unnecessary delays. Based upon the testimony that's been presented this morning, as well as complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There's no reasonable chance of reconciliation. Accordingly, it is ordered by this court that the marriage between the parties be and is thereby dissolved and judgment shall enter granting a divorce from bonds of matrimony. Good luck to both of you. Court will sign the judgment this morning. You'll both be mailed a copy of that. So that will conclude this pretrial conference. You can both zoom out. Have a good rest of the day and good luck.
Thank you.
You're welcome. For the record, this matter is before the court for a continued pretrial conference, as well as the plaintiff's motion for entry of a default judgment divorce. And this hearing is being conducted via Zoom. Present is Attorney Kimberly Kuhn, standing in for Mr. Churchill this morning on behalf of the plaintiff, Jesse Pula. Mr. Pula is also present. In addition, the defendant, Stefania Morris, is present. Good morning, Ms. Morris and Ms. Kuhn, Mr. Pula.
Good morning, Your Honor.
Morning.
Ms. Morris, you obviously didn't file an answer to the complaint for divorce. You failed to appear at the last pretrial conference
Yes,
on
sir.
May 17th, but you've appeared this morning. Have you received a copy of the proposed default judgment divorce?
Yeah, I have memory problems since my heart attack last year, so I don't exactly know where it went.
Okay.
But I do remember.
Did you receive? Did you receive a copy of the proposed default judgment of divorce?
Yes.
Okay. Do you have any objections to the court entering that this morning?
No, sir.
I'm sorry?
No, sir.
Okay. All right. Mr. Pabula, Ms. Morris, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Yes, Your Honor.
Thank you.
Jesse, is it true that you were a resident in the state of Michigan at least 180 days and 10 days
Yes.
in the county of Monroe immediately preceding the filing of this complaint for divorce?
Yes.
True that you and your wife, Stephania Morris, were married on December 21st, 2018 in Ottawa County, Ohio? Is it true
Yes.
that your wife is not pregnant?
Yes.
Is it true that you had no children born of issue of this marriage?
True. Yes.
Is it true that there's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and that there remains no reasonable likelihood that this marriage can be preserved?
Yes.
Did you have an opportunity to carefully review the default judgment of divorce with Mr. Churchill?
Yes.
Do you understand all the terms and conditions contained in the default judgment of divorce?
Yes.
Do you understand that spousal support is barred as to both you and your wife and that neither of you can ever petition the court for an award of spousal support?
Yes.
Are you asking the court to sign the default judgment of divorce and grant your complaint for divorce?
Yes.
Thank you. No further questions, Your Honor.
Thank you, Ms. Kuhn. Ms. Morris, could you please state your name and current mailing address for the record?
My name is Stefania Michelle Morris.
F, drive is in, right, Ms. Morris, did you hear the testimony of your husband, Jesse Pabula, this morning?
Yeah.
Was his testimony true and accurate to the best of your knowledge?
Yes, sir.
Are you currently pregnant?
No, sir.
Do you have any questions for the court regarding any provision in this judgment of divorce?
No, I do not.
Do you have any questions? Okay. Ms. Kuhn, do you have any questions of Ms. Morris?
I don't, Your Honor.
Court is just briefly reviewing the judgment submitted by the clerk's office on base. Scroll through this. No real estate to be divided. There's a prenuptial agreement between the parties. That prenuptial agreement is incorporated in this judgment of divorce. Each party essentially awarded the property that they owned and possessed prior to this 5-year marriage. There are no joint debts. Very well. That's the court appreciates you appearing this morning, Ms. Morris. We always like the parties to participate and at least appear. And we've acknowledged your position. You have no objection to enter this judgment of divorce. Very well. Based upon the testimony that's been presented this morning, as well as claim filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved and judgment shall enter granting a divorce from bonds of matrimony. The court will sign the judgment electronically on base this morning. That will conclude this hearing. Thank you, Ms. Kuhn.
Thank you, Your Honor.
In place of Mr. Churchill. Good luck to you, Ms. Pabula and Ms. Morris.
Thank you.
Right, you can zoom out and have a good rest of the day.
You too, Judge.
For the record, this matter is before the court this morning for a pretrial conference, the same as being conducted via Zoom. Are you Lindsay Rose Peret?
Yes.
Good morning.
Good morning.
The court received this morning a proposed consent judgment of divorce, which appears to have been approved by you as well as your husband. Did you witness your husband sign this judgment?
Yes.
Okay. He lives in Florida, but he's apparently chosen not to appear today. Is that correct?
It appears to be that way.
Okay. So we can proceed without him being present, since you are here because you need to testify that you're not now pregnant and there's no children, and that you testify if you can recognize that he signed this in your presence. The one issue that needs to be addressed, and that is payment of a filing fee. You were on public assistance when you filed this complaint. Are you still receiving public assistance?
Yes, I get Medicaid for me, my daughter.
Okay. Is your husband, is he employed?
I believe he is. I don't know where though.
Okay, the court's going to order him to pay the filing fee, and if he doesn't pay that, the bench warrant's going to issue for his arrest. So I don't know if you want to contribute toward that. He's not here, but that's his problem. The filing fee is $175. The taxpayer shouldn't have to pay for that.
Okay.
Are you employed?
I am. I work for Lazy Boy.
Okay, can you pay this $175?
Not currently, like today.
No, if I gave you a month.
Yeah.
Okay, you tell me what date. I'm going to add this language in the judgment. The court will not waive or suspend the filing fee when you look to be young and able-bodied, capable of employment. So what if I gave you to what, say July 31st, the last business day of July?
That's fine. Thank you.
Okay, it's $175. I'm going to write that in the judgment. I'll put my initials next to it, and you pay that at the county clerk's office, same place where you filed this divorce complaint. And Ms. Peret, if you can't pay by, you got to pay one lump sum. You can't pay installments. They can, for example, you can call and pay it by credit card or the phone if you don't want to come to the courthouse. But they're going to charge, I think, a 3% fee for using your credit card. But that might be easier. If you want to avoid that, the 3%, you may want to just come down and pay cash, but it's got to be one lump sum at the clerk's office. You can't pay partial payments, okay?
Okay.
And if you cannot pay the $175 by July 31st, you need to call the court and say, I need another month. I'll give you another month. But if you blow it off, that's when bench warrants issue. We don't want that to happen.
Okay.
Okay? So, thank you. Ms. Peret, is it true that you filed the complaint for divorce with this court on or about March 7th, 2024?
Yes.
Is it further true that on the date you filed the complaint that you had lived in the county of Monroe for at least 10 days and the state of Michigan at least 6 months?
Yes.
Is it further true that you married Wilson Fabian Irizarry Ortigo on March 18th, 2015? You separated in September of 2022.
Yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed?
Yes.
Is there any chance of reconciliation?
No.
Were there any children born or adopted during your marriage who are still minors?
No.
Are you currently pregnant?
No.
Signed your name to this proposed judgment approving the terms and conditions contained therein. Is that correct?
Yes.
Okay, I'm going to walk through the terms of this with you. You've agreed that spousal support is not awarded. That's forever barred. You cannot come back and ask for spousal support or alimony.
Okay.
We're to divide your personal property. So each will keep the personal property currently in your respective possession, free and clear of any claim on the part of the other. Again, you've been separated for almost a year and a half now. There are no joint debts. Each paying debts in their own name. Each keep their own automobiles. There's no real estate to be divided. And there are no pensions or IRAs to be divided. Is that correct?
Yes.
Finally, you're asking for restoration for the last name of Buttram, Buttram. Is that correct?
Yes.
Okay. When you get a copy of the judgment of divorce, you need to take a copy to the Secretary of State and Social Security to facilitate the legal change for last name, okay?
Okay. Thank you.
The only thing I'm going to add to this judgment is a provision. I'm going to write it in here, put my initials next to it. It says that the plaintiff, Lindsay Peret, shall pay $175 fine fee to Monroe County Clerk on before July 31st, 2024.
Okay.
So you've got about 6 weeks to do that, and just don't forget that because we don't
All right,
want to be picked up on a bench warrant. If you need more time, you call the court and I'll give you more time.
Okay.
And again, once again to confirm, this judgment appears to have a signature on there. Looks like Wilson. I can't read the last name, but it looks like it was signed by him on June 8th, 2024. Did your husband sign this judgment in your presence?
Yes, we signed them together.
Okay. Very well. Based upon the testimony, that's the court would notice now 10:30. This pretrial conference was scheduled for 10 a.m. The defendant was mailed a notice to appear to his address in Cape Coral, Florida. He's not appeared. He's not contacted the court, but the court is satisfied with the testimony provided. by Ms. Peret that Mr. Ortega did in fact approve and sign this judgment. Based upon the testimony that's been presented this morning, as well as Clay Fowler's matter, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. According to the order by this court that the marriage between the parties be and is hereby dissolved, the judgment shall enter granting a divorce with bonds matrimony. The court has signed the judgment. We'll mail a copy to you and to Mr. Ortega. Now we'll conclude this matter, ma'am. So you can zoom out, have a good rest of the day. Engage in mediation with Mr.
Okay,
Walker
thank you.
in front of the court. This hearing is being conducted via Zoom. Present is Attorney Christine Hills representing the plaintiff, Bailey Roberts. Ms. Roberts appears to be present. In addition, Attorney Kirsten Nemick is present representing defendant Kyle Jewell, and Mr. Jewell is present. Good morning, everyone.
Morning.
Good morning, Your Honor.
The court's informed the parties have made some progress and wish to place an agreement on the record. Is that correct?
Yes, Your Honor, I believe we have a full agreement.
Wonderful. And who would like to place an agreement upon the record?
I can do that, and I'm sure Ms. Nemick will help. My notes are, we have a lot of detail in this agreement, so I will do my best. The parties have agreed that they will share joint legal custody of their 2 minor children. There will be no physical custody designation. Parenting time. First of all, my client is still nursing the youngest minor child. She intends to stop nursing when he turns 1. So until he turns 1, there will be no overnights for the youngest minor child with father. Parenting time for the parties on weekdays and weekdays would constitute Monday through Thursday, will be reasonable and liberal with the intent that each party have 2 days for now, again, with overnights with the minor child Harper, but no overnights until Hudson is 1 year old. That would be each week. They will alternate weekend parenting time. The weekend is defined as Friday through Monday, and Mother's Weekend would start this Friday, June 14th, 2024. Of course, we acknowledge Sunday is Father's Day, so Dad would have Father's Day this weekend as agreed by the parties or pursuant to the friend of the court holiday schedule. The parties believe that they will be able to agree to times where the times are left open here. Father's going to return the minor children to mother, however, no later than 8:30 p.m. On his days, and he will pick up the children after work on his days each week. So Dad will be having substantial time with the baby, just not to include overnights for now, but he's going to have multiple contacts with the baby each week. Holidays, again, would be friend of the court holiday schedule unless the parties otherwise mutually agree. We are going to use the Monroe Public Schools calendar for purposes of the holiday schedule. Each party will be entitled to 1 week of uninterrupted parenting time. For mother, that would be 1 week with both kids this summer. Dad would have 1 week with the minor child Harper this summer, and then starting summer 2025, when he will have overnights, he would get both children for his uninterrupted summer parenting time. Mother's going to provide father with the name of the daycare providers that she has considered for the children. She'll do that by tomorrow. Each party is going to let the other party know the name and the date of birth of anyone that they have watching the children for them. Tax exemptions, they're each going to take 1 child when there are 2, and when there's only 1 available, then father would have the exemption for odd tax years and mother for even tax years. Both parties acknowledge, just jumping back to the summer parenting time, both parties acknowledge that mother would be taking her uninterrupted week in July of this year. She has a trip planned up north. She's got a time frame, but no dates nailed down yet, but her uninterrupted week would be in early July this year. And she will let Dad know as soon as those dates are nailed down. The parties are going to agree as to a preferred daycare provider by August 31st, 2024. The kids are waitlisted at a number of different facilities at this point, so they will agree as to which one is their preference. However, it's open to them to agree to a different provider other than their preferred provider as the different daycare providers open up. With regard to extracurricular activities, each party is going to pay 50% of the necessary costs of agreed upon extracurricular activities. And extracurricular activities, unless they are school related, would not be signed up for by either party if it's going to interfere with the other parent's parenting time without the consent of the party whose parenting time would be interfered with. With regard to child support, we're going to have 2 different orders, one for when father is able to provide proof of his unemployment, And when he can show proof of unemployment, his child support would be zero for that time frame. When he is employed, we have child support, which would start May 1st, 2024, and it would be $417 per month for 2 children. I believe Mr. Walker provided both attorneys with a copy of his printout, which designates the two child and the 1 child breakdown. So unless Ms. Nemec feels strongly that we should put that on record, I will just include those figures in the uniform child support order that I will prepare. Uncovered medical over and above the $454 per child per year ordinary medical amount would be split 35% mother, 65% father. Dad will be providing a notice to mother of when he is going to be on unemployment as soon as he receives it, so that she can do some financial planning, since she would not be receiving that $417 per month. With respect to childcare, they are going to share in the cost of childcare for the minor children once that begins. And father's going to pay 65% and mother's going to pay 35%. Those payments would be made directly to the provider. And father is going to provide health insurance for the kids. Mother may, but she has no obligation to do so. And I believe that is the agreement.
Wonderful. Thank you, Ms. Hills. Ms. Nemec, did Ms. Hills accurately state your client's agreement?
Yes, with one clarification, if Ms. Roberts stops breastfeeding before Hudson is 1 year old, then overnights would commence with Mr. Jewell. Otherwise, the expectation is she's going to breastfeed up until he's 1 year old. But if that does end prior to that, then he would be entitled to start exercising overnights.
I would just need to ask my client if she's okay with that.
Yes, that's fine.
Okay.
All right, thank you. Very well, Ms. Roberts, Mr. Jewell, can you both please raise your right hand?
The settlement agreement, which has been placed on the record this morning?
Yes, I have.
And that settlement agreement was reached as a result of mediation this morning. Is that correct?
Yes.
And you were an active participant in that mediation?
Yes.
You understand all of the terms of this agreement?
Yes.
You have any questions about these issues or this agreement as you sit there right now?
No.
Have you had enough time to think through all of these issues?
Yes.
Are you satisfied with my services on your behalf?
Yes.
And do you believe at this point in time that this agreement is in the best interest of your children?
Yes.
All right, I have no further questions. Thank you.
Thank you, Ms. Hills. Ms. Nemec, do you have any questions for Ms. Roberts?
I do not, thank you.
Questions, Mr. Jewell, please.
Kyle, can you state your name for the record?
Kyle Jewell?
And you engaged in mediation with Mr. Walker this morning, correct?
Yes,
And you heard the agreement that Ms. Hills just placed on the record?
I did.
Did it accurately reflect the agreement that you entered into through mediation this morning?
Yes,
Okay. Do you have any questions about it?
I do not.
Do you understand it?
I do.
Have you had time to think about it?
Yes,
Have you had time to discuss it with me?
yes,
At the present time, do you believe that the agreement is in your children's best interest?
I do.
Okay. I have nothing. Oh, are you satisfied with my representation?
Yes, I am.
I have nothing further, Your Honor.
Thank you, Ms. Nemec. Ms. Hills, do you have any questions of Mr. Jewell?
No, Your Honor, thank you.
You'll prepare the order, Ms.
I will.
Hills? All right,
Yeah.
thank you. And with this agreement of record, can we vacate the hearing scheduled for July 2nd at 10:30?
Yes, I'm sorry. I had that in my notes and didn't say it. So yes.
Wonderful. All right, that hearing date will be vacated. The court would like to thank Mr. Walker for his fine efforts this morning, helping facilitate amicable resolution, particularly as well as, of course, the council, Ms. Hills and Ms. Nemec, for helping facilitate amicable resolution between the parents. And the court would applaud you, Ms. Roberts and Mr. Jewell, for reaching your own agreement. The reality is, you know better than anyone in this world what's best for your 2 children. And so I applaud you for reaching this agreement. Of course, as the children get older, you'll need to make adjustments, but your children will thrive if you are both on the same page for their benefit. I applaud you for reaching this agreement, and hopefully the challenges that may rise in the future, that you can work through those together. You're assisted by 2 very capable family law practitioners, and the court appreciates those attorneys being proactive in scheduling this for mediation to move matters forward. The court believes and finds the agreement of the parents to be in the best interest of minor children. The court will accordingly adopt the agreement and enter the order upon presentment. All right, thank you all. That will conclude. You can all zoom out. Have a good rest of the day.
All right. Thank you, Your Honor. You too.
Thank you.
For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. It appears that, ma'am, could you state your name? You're Tamila?
I'm
Mays,
Tamala
correct?
Mays. I'm Tamala
Okay.
Mays.
All right, good afternoon. And Jersal Mays Senior is also present.
Yes, Jerso Mays here.
All right, good afternoon.
Good
Of course, we
afternoon.
received just a blank judgment of divorce that's been signed by Miss Mays and left it blank. Ms. Mays, you were instructed to mail this to your husband for his review and approval.
Okay, I wasn't aware that I had to mail that to him. He's in Mississippi and I'm here in Michigan. When I talked to her, she said to make sure that he was on the call during today.
Understand, he needs to, you're given written instructions attached to it. It says, complete, sign your name, and submit it to the other side. So you've not
Yes,
completed
sir.
it, and you've not submitted to the other side. So let me ask you, both of you, is there anything in dispute? You've been married
No,
17
sir.
years, we've been separated
No.
since January 2023 over years. Is there anything in dispute?
No, sir.
No.
All right, I guess, Mr. Mays, with your permission, rather than send this to you, I can go through this with you and I can initial everything that I add to this judgment, if that's agreeable with you. Thank you. We'll start with you, Ms. Mays, since you're the plaintiff. Can you please state for the record your name and current mailing address?
Yes, Tamala Denise Mays.
Thank you. Ms. Mays, is it true that you filed a complaint for divorce with this court on or about March 11th, 2024?
That's correct, Judge.
Yes.
These are questions for Tamala May first. Then the court will ask you a question, Mr. Mays. Ms. Tamala, is it true that on the date you filed that complaint, you had lived in the county of Monroe for at least 10 days, the state of Michigan at least 6 months?
Yes,
Is it further true that you married Giselle Mays Sr. on April 7, 2007, and you separated in January of 2023?
correct.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed?
Yes.
Is there any chance of reconciliation?
No.
Were there any children born or adopted during your marriage who are still minors?
No, Your Honor.
Are you currently pregnant?
No.
All right, to Mr. Mays, can you please state your name and current mailing address for the record?
Jerso Wayne Mays.
Thank you. And you're a senior, is that correct?
Yes.
Okay. Mr. Mays, did you hear the testimony of your wife, Tamila, this afternoon?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes, Your Honor.
Okay. What the court has in front of it is a 2-page form judgment divorce. It's a form judgment. I just got to fill in I got to check the boxes. So I'm going to read these boxes with you. And if you both agree and with your permission, the court will X the boxes. I'll put my initials next to that. And then that'll eliminate having to mail you the judgment, unless you want to be mailed the judgment before we sign it. Otherwise, the court will mail you a copy, of course, after we sign it. So the first issue is spousal support or alimony. Do you both agree that spousal support is not awarded and that's forever barred?
Correct. I agree.
Yes.
Okay, so I'll check the box. Neither party is awarded spousal support. Spousal support is forever barred. Check that box. I'll put my initials next to that. The next category is personal property. Have you each divided your personal property? Been separated for over a year now.
There is no
Yes.
property.
Personal property, I mean, pots and pans and things you accumulated over 17 years of marriage.
Yes.
Yes, it's been separated. Yes.
I can check the box at each party. I can check the box at each party's awarded the personal property currently in their possession, free and clear of any claim on the part of the other. Is that correct?
Yes, Your Honor.
Correct. Yes, Your Honor.
I will do that. I'll check.
I was requesting for my maiden name back. That was the only thing I was.
We'll get to that and we'll certainly do that. Debts. Are there any joint debts that need to be divided?
No, Your Honor.
No, Your Honor.
Okay, there are no debts to be divided. Each will pay debts in their own name.
Correct.
Yes, Your Honor.
Motor vehicles. Each will get their own motor vehicle and pay
Yes.
the debt they're on. Is that correct?
Yes,
Yes.
Your Honor.
In other words, the vehicle you own, Tamla, is in titled in your name, and the vehicle owned by Mr. Mason is titled in his name. Is that correct?
That is correct, Your
Yes, Your
Honor.
Honor.
Real property. Do you own any real estate?
No,
No.
Your Honor.
Okay, so just in case no real estate to be divided. Next is pension benefits. If you have pension benefits, do you agree that each will keep their own free and clear of any claim on the part of the other?
Correct.
I agree.
Yes, Your Honor.
Okay, I'll check that box. Each party is awarded his or her own pensions, annuities, IRAs, other types of retirement plans. Next, there's a filing fee of $175 that needs to be addressed and paid. When you file this complaint, Ms. Mays, you advise the clerk that you're receiving public assistance.
Yes, Your Honor.
Are you still receiving public assistance?
Yes, Your Honor.
Are you employed?
No, I am not.
Okay. Are you disabled?
I have disabled. I get SSD.
Okay. Mr. Mays, are you employed?
Self-employed.
I'm sorry?
Self-employed.
Okay. Well, the court's going to order you to pay a $175 filing fee to the Monroe County Clerk. The taxpayer shouldn't have to pay for that. And I can give you time to pay that. Now, if Ms. Mays wants to contribute toward that, that's fine. But or if you want to share that cost, but it's got to be paid Monroe County Clerk. I'll give you as much time as you need to pay that. For example, if you need till July 31st, the last business day of July, we can do that. Ms. Mays, you want to talk with your husband about the 175 filing fee?
He can pay it.
How much is it?
$175.
Okay.
And if Ms. Mays is receiving public assistance, court cannot order her to pay that. But since you are employed, the court will order you to pay the 175. Can you pay that by July 31st?
Yes.
Okay. So I'm going to write in this judgment, Mr. Mays, that you shall pay $175 fine fee to Monroe County Clerk on or before July 31st, 2024. Now you can obviously Mississippi, so you can call them and give them do you have a credit card?
Yes.
Okay, you can pay by credit card over the phone. You just give them the case number, and you've got paperwork there, correct? You receive the notice to appear for today's pretrial. I got a case number. Just say what your name. This is my divorce case number. I want to pay the filing fee over the phone.
Okay.
And we'll actually in the judgment, I'll write their phone number. So you got their phone number, the clerk, the direct phone number to pay that. Do you need until July 31st to pay that, or can you pay that by June 28th?
Well, you can give me, if you will, give me the July 31st, but most likely I will pay it before then.
Okay, so I'll say before July 31st. Mr. Mays, if you need additional time to pay that, you call it. The court will give you additional time. Don't blow it off. If you blow it off, that's when bench warrants issue.
Okay.
So please take care of that. All right. And finally, I'm sorry?
What was the phone number? Or you can give it to me later?
I'm going to write this right in the judgment right here. I'll write it in this paperwork and you'll get a copy of the judgment. And do you have a piece of paper and pen? Do you want it right now?
Yes.
That's the
correct. Got it.
Okay, and I'll write that in the judgment as well. Finally, Ms. Mays, you're requesting the restoration of your former name. When you get a copy of this judgment, Ms. Mays, you want to take a copy to the Secretary of State and Social Security to facilitate that change.
Absolutely.
Just take your judgment, copy of judgment divorce to them.
I will do it.
Ms. Mays, do you have any questions for the court?
No, Your Honor, I'm all clear on everything.
Mr. Mays, do you have any questions for the court?
No, I do not, Your Honor.
And everything we've said is recorded, and I have your authority to enter this judgment divorce today, correct?
Yes.
Yes.
All right. Well, just do not forget about the filing fee, Mr. Mays. Based upon the testimony that's been presented this afternoon, as well as the claim filed, this case court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed. There appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved, and judgment shall enter granting a divorce with bonds of matrimony. The court will sign the judgment. You're welcome to have a copy of this. Good luck to both of you. That will conclude this hearing. You can both zoom out and have a good rest of the day.
So are we considered divorced today?
Yes, you're divorced.
Thank you. Thank you, Your Honor.
You're welcome. Good luck to both of you.
Thank you. All right.
No.
Bye.
Welcome.
Okay. Thank you. You're welcome. You are Aaron, and you're going to have to unmute at some point. There we go.
And Jim, I think the only thing we missed was an effective date for the child support. When's it going to start?
I would suggest July 1st, maybe. Was that all right, Jim?
That's fine with me.
Okay.
On the Quadro, we're going to split it less the existing loans, Jim?
Yeah.
Okay, very good.
I don't have any of his pension information. You need to get that together. And we need to get it for, who are we going to have do this? The girl up in Detroit or Westland or what?
Pastrano or Pastrana?
Yeah, Anna
she does a good
Pastrano?
job. Yeah, I'd recommend her, Anna Pastrano.
Yeah, she does a good job.
Yeah, she's the only one I know right now who's worth anything. You know, there's other people that do it, but I've had bad experience.
I've had good fortune with her, both for my Ohio pensions and my Michigan pensions.
She's done a good job on everyone I've sent her to.
Who's going to journalize this? You or me? Or are we going to work on it together or what?
I'll try to get a draft done.
All right.
I'll try to put the agreement on as well.
You'll give me a uniform support order?
Absolutely, sir.
And
Court will call the case. Court will call the case of Aaron Barton versus Lori Barton. For the record, this matter is before the court for a continued pretrial conference. The same is being conducted via Zoom. Present is Attorney Russell Smith, representing the plaintiff, Aaron Barton. Mr. Barton is present. In addition, Attorney James Adre is present, representing the defendant, Lori Barton. Is Ms. Barton present on audio? Oh, she's in your office.
She's here.
Yes.
Okay, we see her. Thank you, Mr. Adre.
Thank you.
The courts, the parties did mediate with Mr. Walker. The court has been informed the parties reached their own agreement. Is that correct, Mr. Smith?
It is, Judge.
Wonderful. Who would like to place agreement on the record?
Your Honor, I'll try. Russell Smith, attorney for Aaron Barton. I would thank Josh Walker for his services. I would also thank Mr. Adre. We did a four-way conference here about a week ago on this matter, made substantial progress. And of course, as the court is aware, the parties that can negotiate their own agreement are way ahead of the game. So I'll congratulate both of them as well.
Absolutely. Thank you, Mr. Smith.
You're welcome. In this matter, Judge, we've agreed to joint legal custody, primary physical custody to mother, parenting time to father with the children as agreed, reasonable and liberal as agreed by the parties. That would take care of that portion of it. Child support would be an amount of $2,100 per month, and that would begin July 1st, 2024. There would be no spousal support awarded to either party, and child support would be specifically barred. Tax exemptions, the parties will each have one tax exemption for state and federal purposes. When the older of the children ages out, they'll alternate the tax exemption for the younger of the children. With regard to insurance, Your Honor, it's my understanding, this is new to my experience, but my client tells me that his employer will continue to carry the mother on the existing policy of health insurance until such time as either of the parties become remarried. So he will be responsible for facilitating that, Judge.
And I'm sorry, Mr. Smith, what if that is not the case? Will he pay then for that continuing coverage through his own out of his own pocket?
No, Judge. No, Judge. If they decide that at some point in the future they can no longer do that, she would be responsible for seeking out her own insurance benefits. But right now, he's been assured by the employer that this will continue into the future, Your Honor.
All right, thank you.
You're welcome. As far as the property settlement goes, the parties have agreed to the division of marital debts. There's a debt to Navient, which is a student loan, which my client, Aaron Barton, will assume and pay. The mother of the children has a credit card through Key Bank. She will assume and pay that. She also has a indebtedness as a lien on her 2022 Ford Explorer through Ford Motor Credit. She's to assume and pay that, hold my client harmless as to any liability. That is a joint debt. He will pay Ford Motor Credit the debt regarding his Ford F-150. That's in his name alone. There's also a camper recreational vehicle, Judge. That is subject to a substantial debt. As a matter of fact, it's underwater quite considerably. My client has agreed to assume the debt on the camper and be awarded all right and interest to it. As far as other aspects of the agreement, Judge, there is a substantial 401k retirement plan that my client has through his employment. It has been agreed that that will be divided equally between the parties by the preparation, facilitation of a QDRO. I believe we've agreed that Anna Pastrana will prepare that. And the division of the account, Your Honor, would be the value of the account less the existing debt. That would establish a net figure for division. And I believe that the existing debt is somewhere in the neighborhood of $14,000. Now, regarding the marital home, Your Honor, it has been agreed between the parties as follows. The parties will continue to own the marital home. Of course, this will be as tenants in common due to the fact of the entry of the divorce. My client has agreed to pay the mortgage payments until the youngest of the two children has graduated from high school and attained the age of 18 years of age, whichever.
No, Russ, 10 years.
Well, Jim, I think we disagree. He agreed to pay it until the youngest of the children had obtained the age of 18 or graduated from school, whichever last occurs.
No, he said today 10 years, and I think that's what Josh has.
Well, how old is the child, Jim?
How old is it?
The youngest is 9.
9.
He just made 9 a couple weeks ago.
Josh, you got 9 years or 10 years on that?
During the mediation
I think-
process, Mr. Barton did say 10 years.
Okay.
10 years.
Was that agreeable?
Yes.
All right. 10 years from today, Your Honor, he will continue to pay the mortgage payment solely. The mortgage payment includes insurance and taxes. That is something that he agreed to do as a benefit for the minor children. At the end of that period of time, the parties will obtain a fair market analysis of the present value of the home. Either party would have the option of purchasing this home from opposing party for the sum of one half of the fair market analysis. If neither party decides to exercise that option, then the property will be listed and sold and the equity split equally between the parties. Now, also, Your Honor, my client has agreed to pay the electric utilities on the property for a 10-year period of time. The mother of the children will be responsible for all other utilities, pay them when due. And also she'll be responsible for what I deem minor maintenance. That's maintenance of the property less than $1,000. Anything over $1,000, which again we'll define as major maintenance, the mother will pay the first $1,000 of this, and the additional expense will be divided 80-20 between the parties, with my client paying the 80% of that sum. Regarding personal property, Judge, it is we're going to put into the judgment of divorce that the parties will agree to the division of personal property. Quite frankly, my client only wants his clothing, jewelry, personal property, and his music items that are located at the home. We don't anticipate any problems with any of that, but it's been agreed that if the parties cannot resolve that issue, they'll submit the issue of the division of personal property to William Godfrey for binding arbitration. That, Judge, I believe, is the full and final agreement. Oh, they will be awarded any financial accounts in their individual names.
Thank you, Mr. Smith. Just to clarify, with respect to the division of the pension by virtue of a qualified domestic relations order, will the parties share equally in the expense of the preparation of that quadro?
I would think so, Judge.
Mr. Adre?
Yes.
Okay, and once again, can you state what the agreement is relative to spousal support, Mr. Smith?
None. Spousal support.
None. Okay.
Forever barred.
I'm sorry.
Ross? I'm sorry. Go ahead, Judge.
All right, Mr. Adre, has Mr. Smith accurately stated your client's agreement?
Russ, did you also indicate he's going to pay the American Express bill?
Is that agreeable, Mr.?
Yeah, that's my bill.
Okay.
Okay.
Yes. He will pay that as well.
And he was going to make a contribution of toward attorney fees.
I don't believe that that was part of the final agreement that we reached. Mr. Walker did not indicate that that was part of the agreement.
He and I talked about it, and he was going to take that to you with a couple of the other aspects of the proposal.
He never talked to me further about it, Jim. Josh, are you on the feed?
Yes. The issue of attorney fees was brought up in mediation, but there was no concrete final agreement on if that was going to be paid or not.
But he says you didn't even present it to him.
We talked about it initially, but when he went and talked to you further and came back, it was not mentioned that I can recall.
Did you want to go back into a breakout room?
Yeah, we can go.
I think we should. I think we should for a couple minutes, if we may, Your Honor.
Okay. Okay. Put yourself in the. Oh, yeah. Andrea, what happened? Where were you?
Oh, I told her I was gonna write that.
Okay, we need your cell phone or something, because when these come on, you need to go right back up here. Absolutely. I don't want to leave attorneys waiting, and because I was heading downstairs too, and the call came right back up. I don't keep attorneys waiting. Gotcha. All right. Yeah, parties once again conferred regarding one last aspect of the settlement agreement. And Mr. Adre, Mr. Smith, have you been able to resolve any issue regarding attorney fees?
We have, Judge. I appreciate you giving us the opportunity to do that. It's been agreed that my client will pay James Adre a sum of $2,500 in attorney fees within 90 days after the entry of the judgment of divorce.
All right. Is that accurate, Mr. Adre?
It is, Your Honor.
All right. All right, to Mr. and Mrs. Barton, can you both please raise your right hand to be sworn, please? The clerk would note, Mr. Smith, we took the proofs back on February 2nd. All we need to do is update our proofs from Miss Barton that she's not now pregnant. But if you want to simply review with, confirm with Mr. Barton his understanding of the settlement agreement, please.
Yes, Judge. Mr. Barton, is your spouse pregnant at the present time, to your knowledge?
No.
Lori, are you pregnant at the present time?
No.
Court
Thank
satisfied?
you. Yes, if you just want to confirm with your client his understanding and agreement as to the settlement terms, please.
Very good. Mr. Barton, you've heard the settlement that we've placed on the record before Judge Braunlich today, have you not?
Yes.
And this is something that we worked out through a conference at Mr. Adre's office, four-party conference, and also a mediation with Josh Walker. Is that correct?
Yes.
Do you believe that the provisions regarding custody are in the best interests of the minor children?
Yes.
Do you understand the child support obligation that you have incurred?
Yes.
You also have agreed to pay the mortgage on the house for 10 years and also the electric bill on the house for 10 years. Do you understand that?
Yes.
And you've also entered into an agreement regarding maintenance on the home that we've placed on the record.
Yes.
You understand that there is no spousal support being awarded to you or your wife. Is that correct?
Yes.
You understand that you cannot come back into court asking for spousal support, that your right for this is forever barred.
Yes.
Mr. Barton, I've represented you throughout this matter, have I not?
Yes.
Are you satisfied with my services up to this point in time?
Yes.
Now, you also understand that you would have a right to go to trial in front of Judge Braunlich on all the matters that we've resolved today. Do you understand that?
Could you repeat that?
You also understand that you had a right to proceed to trial in front of Judge Braunlich on this matter?
Yes.
In that at trial, he may have come up with something similar to this or something completely different. Do you understand that?
Yes.
And are you asking Judge Braunlich to sign a judgment of divorce containing the terms and conditions that we placed on the record today?
Yes.
Thank you, Your Honor. I have no further questions for Mr. Barton.
Thank you, Mr. Smith. Mr. Adre, do you have any questions? First of all, for Mr. Barton.
No, I don't, Your Honor. Thank you.
Questions from Ms. Barton, please.
Lori, introduce yourself to the court.
I'm Lori Barton.
Lori, it is true that we have come to an agreement after extensive negotiations and consultation and the mediation. Is that correct?
Yes.
And it's fair to say you have participated in all aspects of the development of this resolution.
Yes.
Now, the resolution was read onto the record today. Did you understand that?
Yes.
I understand and know that some of the numbers got changed around and they're large and they're small, might be some confusion, but do you feel you've had adequate time to consider whether or not you want to enter into this agreement?
Yes.
And you're entering into the agreement and it's your free and voluntary act indeed, correct?
Correct.
You understand there's no spousal support. You understand that your mortgage on the home is going to be paid for the next 10 years, including the principal, interest, taxes, and insurance. You understand that Mr. Barton is going to pay the electric bill.
Yes.
You understand the obligations you're assuming and the obligations he's assuming. You believe that the parenting time and the child support order are fair and equitable?
Yes.
Are they in the best interests of your children?
Yes.
Are you satisfied with my advice, my representation, and my counsel?
Yes.
You understand that by entering this agreement, if the court adopts it, you can't walk out of here and then tomorrow come back and say, Jim, I've changed my mind.
Yes.
You understand that?
Yes.
It's a full and binding agreement. Do you want the court to adopt this agreement as its order?
Yes.
Do you have any questions of myself, Mr. Smith, or the court with respect to your rights, duties, and obligations under the agreement?
I do.
Do you have any questions of the same three individuals as to Mr. Barton's rights, duties, and responsibilities under the agreement?
I do not.
And you want to confirm that agreement, is that correct?
Correct.
Thank you, Your Honor.
Thank you, Mr. Adre. Mr. Smith, do you have any questions of Ms. Barton?
I do not. Thank you, Your Honor.
You'll prepare the judgment to Mr. Smith?
I will, Judge.
Thank you. Very well, the court would like to thank and acknowledge Mr. Walker for his fine assistance this afternoon, helping facilitate the resolution, as well as, of course, Attorneys Smith and Adre for helping their clients reach their own agreement, which is far better off, Mr. Miss Barton, than having this court make those decisions in trial. It's wonderful you can co-parent your children. Keep in mind, you will not be divorced till the court signs written judgment. Hopefully that will be within the next 30 days. Based, however, on the testimony that's been presented this morning, as well as previously, as well as complaint filed in this case, court finds again the jurisdiction has been established and that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There is no reasonable chance of reconciliation. According upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment will enter granting a divorce from bonds of matrimony. Good luck to both of you. Thank you again, Mr. Smith and Mr. Adre. That will conclude this matter. You can both zoom out and have a good rest of the day.
Thank you, Your Honor. Russ, we'll
Thank
be
you,
in
Judge.
touch.
Yes, sir. Thanks, Jim.
Thank you.
John.
Thanks, John.
I know.
It says she's joining, but it's been saying that for like the last half minute to a minute, and I don't know what that means.
I know when we started mediation with Stephanie, she was having some issues. I think her Wi-Fi is slow at her home. So maybe she's going to try again.
Okay, we'll give her a few minutes, and if there's a problem, we can she can call and appear by audio.
Okay.
I'm unmuted.
Okay, perfect. Okay.
On the matter of Pamela Thomas Puccetti.
For the record, this matter is before the court for a pretrial conference. Subsequent to the parties having engaged in mediation with Ms. Peret for the front of the court this afternoon. Present for the Zoom hearing is Attorney Carmen Moyer representing the plaintiff Pamela Puccetti, and Ms. Puccetti is present. In addition, Attorney William Godfrey is present representing the defendant Thomas Puccetti, and Mr. Puccetti is present with Mr. Godfrey. The court has been informed the parties have reached their own agreement. Is that correct, Ms. Moyer?
Yes, it is.
Wonderful. Who would like to place that agreement on the record?
Judge, I'll do that with the court's permission.
Please, Mr. Godfrey.
Thank you. We have no minor children, so this is just stuff between the parties. We'll start with the real estate. It's located at this property is awarded to husband. Wife shall execute an appropriate quitclaim deed to transfer her interest in this property to husband. I will prepare that quitclaim deed and I will provide it to Ms. Moyer, who will have her client sign it. Ms. Moyer will hold that quitclaim deed until the happening of the following events. One, payment of the sum of $178,500 in cash to wife, and removal of wife's name from the principal mortgage that is on the property, as well as a home equity line that is on the property. Those three things, the cash and the removal of the wife's name from the mortgage and the home equity line, is to be done within 4 months from the entry of the judgment here. That 4 months, then the payment has to be made. Husband will be responsible for making timely payments on the mortgage and the home equity line. Those timely means by the due date. The court would retain jurisdiction over this property, that if the refinance, the removal of wife's name, the payment of the cash, and or if timely payments are not made, then the parties can, or the wife can petition the court for any relief that court deems appropriate. Appropriate relief could include the ordered sale of the real estate. Husband would hold wife harmless from any past, present, or future obligations concerning the home. All utilities on the home, services, and everything else, insurance would be put into husband's name. Any questions by the parties concerning the real estate?
No.
All right. Automobiles. Wife is awarded the 2014 Buick Enclave. Husband is awarded the following: the 2006 Ford F-150, the 2002 Chevy Silverado, the 2004 Honda Accord, the 2001 Toyota Camry, the 2019 Dodge Charger, the 1974 Corvette, a 2001 Dutchman bunkhouse travel trailer, pull behind, as well as a 1998 and two 2006 four-wheelers. Husband is awarded those. Each party is responsible for the insurance, plates, expenses, and cost in relation to the items that they have been awarded, and they shall hold the other party harmless from any liability thereon.
The title to the Camry is in...
Yeah, as to a couple of these items, Judge, the Camry is technically in Nathan's name as well, and the Dodge Charger is also in Nathan's name.
Sold.
And
Charger sold.
All right.
But the Camry's still in Nathan and Pam's name. Or it's in Pam's name.
But anyway, it's going to go either from Pam to husband, or husband or Pam to Nathan. Either way, it's going to be for the benefit of Nathan. Bank account. Any more questions on the motorized items?
Nope, we're good.
All right. Bank accounts, there is the following accounts, husband is going to be awarded. First Merchants checking ending in 0080. Another checking account at First Merchants ending in 0525, as well as husband's account at Directions Credit Union. Wife is awarded her account at First Merchants Bank ending in 3461. Whatever is in those accounts, each party keeps their monies.
What do I do about credit card she has for 0080?
As to 0080, once you deplete that, it can be just closed out.
I'll give it back to you.
All right. Or return that.
I'll return it to you.
The next financial account are investment accounts. They're both at Schwab. One is in wife's name ending in 9747, and the other one is ending in 9698. Those two accounts are awarded to wife. That value has been taken in, the value there has been taken into account in the global settlement. As to the IRA accounts, all and retirement accounts, all of those are going to be equalized using a valuation date of March 31st of 2024. Ms. Ann Pastrana would be doing that equalization or valuation of all of those accounts. The parties shall cooperate with her to get their account information as of the March 31st, 2024 date to her. Once she adds all of those up, they will be equalized. Wife has one IRA at Schwab, and she will be keeping that. No quadro there. That's just going to be deducted as her share. And then from a husband's IRA at Lincoln, IRA at annuity at Lincoln, a rollover IRA at Schwab, and an SAS 401k account, those would be all added up. Husband gets a credit for premarital of $35,974. Whatever is left to equalize it would be rolled over from husband's IRA at Schwab, and that would be one rollover. If there's multiple investments at Schwab, it would come out of that equalized out of those accounts. Any gain or loss from the valuation date is allocated to each party's shares. So if it went up 5% since March 31st, each gets an extra 5%. If it went down, obviously it goes down. Any questions concerning retirements?
You're going to share the cost of the equalization for
Good point. The cost of the equalization and the quadro preparation and any cost by the plan administrator to implement the quadro would be shared 50-50 by the parties. Thanks for catching that. Any other questions?
No.
No.
All right. Personal property, each party would keep the personal property items that they may have in their possession, free and clear of any claim, title, or the other or interest of the other party, with the exception of these items that are in a husband's possession at the marital home at Michigan. Wife is awarded the pet Charlie, the adjustable bed and mattress, silverware gift from Aunt Dorothy, pottery consisting of owl and leaf. That was a gift from Mary, some wall art, pots for outdoor plants. Stainless steel cookware, which is all awarded to wife except any duplicates of the stainless steel cookware husband would keep. The family photo album would go, the original would go to wife. If husband wants copies of any of those photos and there's not duplicates, husband will make the copies and the parties will share that cost 50-50. There is artwork that still needs to be divided, and the parties believe they can divide the artwork on their own. I'm not going to indicate any arbitration on that. They're just going to divide their artwork on their own. That is the personal property. Any questions on that?
No.
All right. Life insurance, each party keeps their own. Husband had a Columbus Life and a Mutual of Omaha, so those term payments can be stopped. And if they want to stop their payment on their whole life policy, they can do that as well. Wife would keep her Columbus Life. All of the cash surrender value was reconciled as part of this agreement. The parties have already filed their 2023 3 tax return and shared the refund. As to marital debt, there was a Firestone credit card, American Express, a Costco City card, and Bank of America Visa, which husband is going to be responsible for. If wife had any card, she has indicated she will not be charging on that going forward, and her cards can be canceled. Once those are paid off, husband would pay those off timely, and either wife can return the card to husband or they get canceled.
Yes, I can do that.
There was a student loan issue. Husband had or indicated he is responsible on a Parent Plus federal student loan for Dominic. Payment of that is between husband and Dominic, and wife has no responsibility on any part of that Parent Plus federal student loan.
Part of that borrowing though was for his.
All right. Maiden name. If wife seeks restoration of her maiden name, she can have that restored to her. It's Pamela. Health insurance coverage. Each party is responsible for their own health insurance coverage post-divorce at their own expense. If either party incurred any medical procedure that was not covered by insurance, each party shall be solely responsible for payment of their own uninsured medical expense. Attorney fees. Each party is responsible for payment of their own attorney fees and cost. Spousal support as to husband is forever barred. Spousal support as to wife is granted. A uniform spousal support order would enter. Spousal support would be paid by husband to wife in the amount of $2,000 for a period of 36 months. This is non-modifiable. It shall be commenced July 1, 2024 by a direct payment, and as of August 1st, it goes through the friend of the court. It terminates upon wife's death, wife's remarriage, or 36 months, whichever comes first. I will prepare the uniform spousal support order, and that payments would be through the friend of the court. The parties will divide their cell phone plans. Each would keep their own number and phone, but they've got to divide that. Car insurance needs to be split. If wife wants to continue a jewelry insurance writer, she may do so at her cost, and husband shall cooperate and provide the background or historical data so that jewelry insurance writer can be transferred and wife can start paying for that. All streaming services, the parties will need to divide if they have not already divided those, Netflix, Amazon, those things. There was a couple of issues dealing with the sale of a commercial real estate that is moot or taken into account in the global settlement, as well as wife's argument that money that was given or loaned by her mother should be taken into account. All of those issues have been resolved and the matter is concluded. Husband has made the position on the student loan that a portion of that student loan went for meals and housing, but what Dominic doesn't pay on that, you're going to be responsible for payment of. That's the agreement.
Thank you, Mr. Godfrey. And again, the spousal support is non-modifiable in terms of amount as well as duration, correct?
That is correct, Judge.
All right. Thank you, Mr. Godfrey. Ms. Moyer, did Mr. Godfrey accurately state your client's agreement?
He did, and I want to thank everybody and Mr. Godfrey especially for doing such a yeoman's job and all of their hard work.
All right. Thank you, Ms. Moyer. Mr. and Mrs. Puccetti, will you both please raise your right hand to be sworn, please?
At the time you filed your complaint for divorce, had you been a resident of the state of Michigan for at least 6 months and the county of Monroe for at least 10 days?
Yes, ma'am.
And at the date you filed your complaint for divorce, which was on or about February 27th of 2024, were all of the allegations true at the time?
Yes.
And are they still true today?
Yes.
And one of those allegations was that there had been a breakdown of the marriage relationship such that the objects of matrimony could not be preserved and there is no chance of reconciliation. Is that true?
Yes.
Are you currently pregnant?
No.
Did you hear the agreement that Mr. Godfrey placed on the record?
Yes.
Did you understand it?
Yes.
And do you feel that you had ample time to discuss the proposed agreement and that you had ample time with me to discuss it with me as well?
Yes.
And do you believe that the agreement equitably divides all of the property between you and your husband?
Yes.
And it's a fair distribution?
Yes.
And do you understand that the award of spousal support as to your husband is forever barred? That means he can't ever come to court and petition the court for spousal support. Do you understand that?
Yes.
And the award of spousal support to you, you understand that it's final, binding, and non-modifiable, and that means that you can't come into the court and ask the court to change the amount or the duration. Do you understand that?
Yes.
And you understand that by asking the court or signing a judgment that contains all of these terms and asking the court to enter that judgment, you're waiving your right to trial where you could do better, worse, or the same. Do you understand that?
Yes, I understand.
And you will be signing the judgment that Mr. Godfrey is going to draft for us that contains all of these terms. Is that correct?
That's correct.
Do you have any questions for me or for the court?
The only question I had was with regard to health insurance. When should that be, like, when will the transition happen for health insurance?
You'll be starting to pay yours when the judgment is the first day of the first month after the judgment gets entered.
Thank you.
Yes. Nothing further, Your Honor.
Thank you, Ms. Moyer. Mr. Godfrey, do you have any questions of Ms. Puccetti?
Ms. Puccetti, have you revealed all of your assets and liabilities during the course of these proceedings?
Yes, sir.
Thank you. No further questions, Judge.
All right, Mr. Godfrey, questions for Mr. Puccetti, please.
Yes, will you state your name for the record, please?
Thomas Albert Puccetti.
And you've been involved in the mediation process today?
Correct.
And you've heard the settlement agreement that I placed on the record here today?
Yes.
Is that your agreement?
Yes.
You're aware that if you wanted to, you could have proceeded to a trial before Judge Braunlich, and you could have done better, you could have done worse, you could have done about the same, but you want the court to approve this agreement?
Yes.
Do you have any questions of me?
No.
Have you revealed all of your assets and liabilities?
Yes.
You're aware that you have spousal support barred as to yourself, and you can never come to court asking spousal support?
Correct.
And you're aware that spousal support, you're responsible for payment of $2,000 per month for a period of 36 months?
Correct.
Any questions of me?
No.
I have no further questions, Judge.
Thank you, Mr. Godfrey. Mrs. Moyer, do you have any questions for Mr. Puccetti?
I do not.
All right, Mr. Godfrey, who will you prepare the judgment?
I'm going to do all of it, Judge. The judgment, the quitclaim deed, and the uniform spousal support order.
Thank you. Very well, the court would like to thank and acknowledge Mr. Peret for her fine assistance in helping facilitate amicable resolution of this matter between the parties. The court would also, of course, acknowledge attorneys Moyer and Godfrey for helping facilitate resolution. The court would applaud you, Mr. Puccetti. Without question, the best resolution of matters of this nature is one in which you both participate. So you have this afternoon, as opposed to this court making these decisions. Keep in mind, you'll not be divorced until the court signs a written judgment. Hopefully that will be within the next couple of weeks. Based, however, on the testimony that's been presented this afternoon, as well as the complaint filed, this case court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed, and unfortunately, there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receiving the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved. The judgment shall enter granting a divorce from bonds of matrimony. Good luck to both of you. Thank you again, Mr. Godfrey and Ms. Moyer. That will conclude the hearing. You can all zoom out. Have a good rest of the day, Mr. Godfrey. Have a nice weekend.
Thank you.
Thank you, Your Honor.
You too,
Thank you,
Judge.
Stephanie.
Thanks, Stephanie.
Bye.